distinguished speakers that we will hear in the course of the day. Professor Nicola Kyriakidis, I practiced it. And all the speakers of today, Professor Achilles Emilianides, the Dean of this Faculty of Law at the University of Nicosia, and we are very grateful for his cooperation. Mr. Michaelis Forkas from the Bar Association, our good friend, Professor Pascal Pichonaz, the former president of the ELI, European Law Institute, who was encouraging and was integral part of the group that generated the ELI Mount Scopus European Judicial Standards of Judicial Independence. He organized many webinars, conferences to market this idea of judicial independence in all its aspects, as was detailed both by Pascal and by our good partner for judicial independence, Nicolas Bell, Deputy Head of the Unit, the Justice Policy and the Rule of Law, and Directorate in the Directorate General of the Justice and Consumer Department in the European Union, who is also very active in marketing this idea, because the judicial independence cannot stay within the legal rooms or professional conferences. Judicial independence has to be educated to the general public, and so the publications of the EU are very important. I want to mention the Honorable Chief Justices and Presidents and Judges of courts, past and present, who are here with us. Former Chief Justice of Malta, Vincent Di Gaetano, President of the Supreme Court of Montenegro, Valentina Pavlicic, and also Judge Natasha Palvecic. So I'm very grateful for your participation, which shows your commitment to judicial independence and the quality of justice that you deliver to the public. I want to mention that we have here with us also Alexander Trunk, who will be organizing the next meeting of our association. It will be combined with an event on East Law, and so we will send you the details about the upcoming conference and put down 16 February. This is an intensive year. We are going to have another conference later on. Some years we have only one conference. Some years we have more than one conference, and some years we don't have conference. So we equalize it. It is my pleasure to address this conference this morning at the University of Nicosia on the very important subject on liberal democracy and judicial independence, with view to the ELI Mount Scopus Standards on Judicial Independence, organized by the Procedural Law Unit at the University of Nicosia in cooperation with the International Association of Judicial Independence and World Peace, which I will refer to as JIWP. So if you want to look at the website, just remember JIWP.org. Then you can see our activities JIWP is active now for over 40 years. You can't believe it. 40 years have passed, and we are active in a number of areas. First, JIWP has drafted standards of judicial independence and judicial ethics. You just heard about the ELI, Mount Scopus, European Judicial Standards of Judicial Independence, which is based on a revision of the Mount Scopus standards, as I just mentioned, and that was explained in detail by Professor Pishonaz, our good friend and partner. And we are very proud that our work is a basis for this contribution to the thinking and to the promotion of, I would say, democracy and the values of the rule of law in Europe and beyond Europe. But the origin started in the beginning of the 80s with the New Delhi Code on minimum standards of judicial independence, which was approved in New Delhi in 1982. We normally name the text of the standards according to the location of the approval. This is the normal culture in legal world. So, and then it was revised. This code was revised in 2008 in Jerusalem on Mount Scopus. That's the origin of the campus of the Hebrew University is in Mount Scopus in Jerusalem. And then later on we had also the Bologna-Milan Global Code of Judicial Ethics 2015. So Bologna and Milan are also given the credit of hosting the conference that we approved this code. So we are really very happy to be part of this universal effort to maintain judicial independence and to support democracy. You can find in this nice report of the last year, you can find at page 95, while I'm speaking, you can take a look at it. There is a survey or an analysis of the ELI Mount Scopus standards in a it's in fact has a number of parts on foundations of judicial independence. What are the fundamental values? The judicial governance that was mentioned already by Professor Pishonaz, judicial appointments and evaluation, ethical standards, discipline. So you can take a look at it when you have time. The second area where we are active is that we have published 6 volumes on judicial independence. The last one copy is with me to give you in appreciation of your cooperation. This volume is called Judicial Independence, Cornerstone of Democracy. Because as all of us know, without judicial independence, there is no democracy. It is a backbone of democracy. Also, the third area is that we are holding conferences. We have now held conferences, over 20 conferences. We are going around the world. They say join the Navy and see the world. Join the universities and see the world now. So we had in London, Sean McConville was the organizer. In Claremont, Hiram Chodush, Professor Hiram Chodush was the organizer. in Hong Kong, Anton Kurey, in Vienna, Walter Reschberger, in Krakow, our friend here, who was the co-reporter together with Sophie Tureinen, Leah Wortman, and myself, who carried the burden of moving this project of shaping the European judicial standards of judicial independence. In Milan, our friend Giuseppe Ferrari, which you will hear on online later on. Frederick is here and he's smiling, and you cannot miss him because he's. When I stand next to him, I know that I'm very, very short. But because we're good friends, I feel equal. We have a conference. We had a conference in Ghent, organized by a very, very dear friend, the late Professor Marcel Stolme, who was also president of the International Association of Procedural Law, and we will hear Matthias, his son, in the course of the day. Cambridge was one of the locations. It was organized by Professor Christopher Forsyth, who was also the editor of the second volume together with me. Christopher Forsyth was the director of the Public Law Center. In Public Law Center and the Hebrew University were co-sponsors of the project until 2018. And then the new director of the Public Law Center thought that they have other things to do, and we respect it. But until then, we have to give them credit. Christopher was very committed to this project. Of course, we hosted in Jerusalem, as I mentioned, a number of times. So we were all around the world giving equal attention to North America, Eastern Asia. Of course, most of the conferences were in Europe, and that means how important is Europe in this idea. Before making few remarks on the content of the subject, on liberal democracy and judicial independence, I want to thank all the speakers who came from all around the world to participate in this conference. I want to thank Nicola for excellent organization, and I want to thank his team, every one of them, Galatea, Georgia, Eva, Despina. You see how many people here were able to mobilize in order to produce such an excellent gathering. And of course, I want to thank the Dean, Professor Achilles Emilianadis, and this is already the second time that I'm meeting with you, and I appreciate very much your cooperation. I now wish to make a few points on the challenges of liberal democracy and judicial independence in an era of backsliding of democracy, or sometimes it's called regress of democracy. Over the past decade, and a little bit more, we have witnessed a profound transformation in the global democratic landscape. What once appeared to be the steady expansion of liberal democracy has given way to a troubling pattern of democratic backsliding. Yet this regression does not arrive with tanks in the streets or abrupt constitutional collapse. Instead, it comes quietly, gradually, and under the cloak of legality. Elected governments, often enjoying genuine democratic mandates, have used formal legislative tools, administrative reforms, and constitutional amendments to reshape the political order from within. The external form of democracy remains intact, but its liberal substance begins to erode. To understand this phenomenon, we must first distinguish clearly between the types of democratic regimes, for not all democracies are equal in their constitutional depth. A liberal democracy is not defined merely by periodic elections. Elections are not enough. It rests on 5 co-equal foundations: human dignity, human rights, popular sovereignty, the rule of law, equality, and fundamental rights. These values impose substantive limits on political authority. They ensure independent courts, pluralistic media, and meaningful checks and balances. An electoral democracy, which is the second category, by contrast, prizes majority rule, but lacks these liberal anchors. It may conduct free elections, yet without constitutional safeguards, without judicial independence, without freedom of expression, without protection of minorities. Such a system risks becoming an electoral autocracy, which is the third category. And once a democracy drifts into electoral a democracy without liberal constraints, the road to authoritarianism becomes dangerously short. This typology is essential for diagnosing democratic backsliding. Liberal democracy is a dual commitment. The people authorize government through elections, but constitutionalism, rights, courts, and institutional constraints defines the permissible limits of that authority. Remove these limits, the democracy becomes a tool for its own undoing. Across countries, as diverse as Hungary, Poland, I stopped for a minute because I can't believe that I have to say Israel, because for years we were feeling that we are a fully democratic country with full commitment to democratic values, but now I have to say as diverse as Hungary, Poland, Israel, Turkey, and I have to mention emerging in the United States. This is also another big surprise. And we find the same unmistakable pattern. The very first target is always the judiciary. Why? Because an independent judiciary is a central obstacle to any project of democratic erosion. It's the cornerstone of democracy. Governments alter judicial appointment procedures. They change retirement ages. They create disciplinary bodies loyal to the executive. They strip courts of jurisdiction. They pack the benches. They circumvent the review by the judiciary of actions, or undermine compliance with judgments. Each measure may appear technical, even harmless, but taken together, they hollow out the core of judicial independence, both its formal guarantees and its real-world operation. Hungary offers an early and powerful example: a new constitution rushed through in 9 days, court packing, jurisdiction stripping, and annulment of 2 decades of constitutional jurisprudence. Poland followed, politicizing the National Council of the Judiciary, establishing a disciplinary chamber to intimidate judges, and reshaping the media and electoral framework to entrench political advantage. Israel, too, now faces an unprecedented constitutional crisis. Since 2023, the roots was 2019, when the prime minister was indicted for serious crimes. But the impact of the crisis began in 2023. In that year, the independence of key institutions has been challenged through rapid, coordinated initiatives, efforts to curb judicial review, reshape the appointments committee, politicize the disciplinary mechanism, and assert governmental control over the police, prosecution, civil service, and even security service. Only recently did the Supreme Court in 2024, the Supreme Court of Israel responded decisively, affirming its authority to review basic laws, that is, constitutional amendments in Israeli, striking down amendments that undermined Israel's democratic character on the theories of limits on the constitution that cannot violate the basic structure of the system of government. So this is one of the options for intervening even in constitutional amendments. Yet, judicial transformation is only one front in democratic backsliding. As we have seen in several jurisdictions, governments increasingly turn to the capture of public broadcasting and mainstream media. By converting public broadcasters into partisan instruments, by regulating or intimidating critical outlets, or by amplifying state-aligned narratives, executives over the countries weaken the pluralistic information environment and liberal democracy that liberal democracy requires. When the media loses its independence, the public loses its ability to hold power to account, and democratic erosion accelerates. Today, democratic backsliding is no longer confined to legislators and executives alone. Digital platforms have become new arena of constitutional vulnerability. The annulment of Romania's 2024 elections by the court of the Constitutional Court of Romania, which is a landmark case, following evidence of massive algorithmic manipulation and foreign interference, reveals how disinformation can distort voters' freedom of opinion and equality of opportunity. In the digital age, the legal tools of militant democracy must adapt to a world where elections can be undermined invisibly and at a scale. But amid these worrisome developments, there are also some democratic responses worth highlighting. In 2023, a new election in Poland, and after the new election, in coordination with the EU, Poland passed a draft law, which is not yet final, draft law on the restoration of constitutional order in the judiciary. It represents a rare and sophisticated attempt to reverse institutional capture through lawful, proportionate means, acknowledging the original sin of the politicized National Judicial Council, and nearly 2,500, let's call it tainted appointments, because the EU judicial authorities and the executive authorities declared this process unlawful and unconstitutional, and therefore I can call it tainted appointments. The proposal created three groups in these 2,500 appointments. The first one is called green. Green means, okay, 1,000 entry-level judges whose appointments will be reviewed, but they will stay in office. Yellow group is the people who were promoted inside the system they can retain, but they have to compete for the same position. And the red group, the first-time appointees, who must return to the previous profession or apply or reapply under constitutional procedures. This careful differentiation avoids invalidating thousands of past judgments and preserve the legal certainty while restoring the legitimacy. Now, unfortunately, the draft law has had to be approved by the president, but of Poland. The new president was elected after we had a big event in Brussels together with the Minister of Justice of Poland and together with our friend Mr. Bell, discussing in detail all these reforms. But I think it is the first attempt of a jurisdiction to try to amend what has been done by, let's say, a deficient democracy. And so I assume that the same principle would apply. That means if you bring someone from the inside of the institution, it makes sense not to interfere in his appointment. But if you bring someone from outside the system, that shows improper motives. One of the principles that we established in Standard 38 of the European ELI standards was that we have to check the motives of that stand behind the measure. What then, to come to near conclusion, what then can the courts do in order to meet these challenges that I just mentioned? One, to use the doctrine of unconstitutional constitutional amendments. This doctrine recognizes that even a body empowered to amend the Constitution may not destroy its basic structure. Second, the doctrine of abuse of constituent authority prevents cynical, personal, or temporary changes enacted under the label of constitutional amendment. This is what the Supreme Court of Israel used in order to annul the amendments in these two doctrines. It was also done, to give you another example, in India in 2016. There was an attempt to change the judicial collegium, which is the procedure of appointments of senior judges in India. They did it by a law of parliament, so the court declared it unconstitutional. So they did it in a constitutional amendment, the same thing, and the court says, okay, also unconstitutional, even though it was amended by the Constitution. And I'm proud that I was quoted in this India judgment, as in other cases. But this is very important to say, that even legislators who take the cloak of constitutional amendment or the gown of constitutional amendments, they are not immune from judicial review. The third doctrine is the militant democracy. Democracy must defend itself. So if there are new challenges, democracy has to bring new defenses to protect the structure of the democracy. Ladies and gentlemen, the challenge before us is clear. Liberal democracy must be defended not only at the ballot box, but also in the courts, in constitutional reforms, in public media sphere, and in the digital public square. If courts are entrusted with the tools to enforce constitutional limits, and if political institutions are willing to restore them when breached, then, even after periods of serious decline, the promise of democracy can be maintained. Thank you.